this is a complex area of policy debate in Washington, and it has been for basically the entire time that the Trump administration has been seated. So, we are, I guess, maybe 15 months, 16 months into the Trump administration. And, the Clarity Act, the, global market structure rules for the crypto industry. Sorry to use the crypto industry, but it is
I'll
for the
forgive you.
crypto industry, have been being debated. And as you mentioned, as Bitcoiners, about 95% of this bill is kind of meaningless to us. A lot of this is about how to normalize and harmonize the SEC, the CFTC, what qualifies as a decentralized project versus a centralized project, what qualifies as an unregistered securities offering versus something that you're allowed to do. There are a lot of, I'll say, consequential things that are in this larger bill, but they largely relate to the non-Bitcoin universe. As you mentioned, the BRCA, or what I'll refer to as the developer protections piece of the bill, is really what we care about as Bitcoiners because, as we've seen over the last 2 years with the prosecutions of the Samurai developers and the Tornado Cash developers, we really needed to create this safe harbor for open source software developers in the United States to understand that they could safely exercise their free speech rights by writing software code, as has been held by the Supreme Court in U.S. versus Bernstein back to the original crypto wars, and as was understood as recently as 2019 by FinCEN, which is one of the financial regulators here in the United States, when they issued their guidance that said that if you never take possession of customer funds and you are not a controlling entity, that you do not need to be registered as a money transmitter or KYC AML, the users of your software. And so, the BRCA was originally a standalone bill that was folded into this larger market structure package. And for the majority of the legislative process with Clarity, it was great. Nobody was really bothered by it. It passed, overwhelmingly out of the House on a bipartisan basis. I think it, 3-1 was the, vote in total, that it passed through the House. And then it came to the Senate, but as we've seen over the last, sort of 9 months or so, as the legislative process just ground into the mud and effectively stopped moving, the debates around developer protections has now become more politically charged for some reason, and you see kind of the law and order, surveillance interests in Washington, D.C. really going to the mat, pushing back and fighting against the idea that this full safe harbor for open source software developers would be able to exist in this bill and be something that they would tolerate. And so what we saw in the most recent fighting to get the bill from out of the Finance Committee onto the full floor of the Senate was the insertion of this clause, subsection D, in Title 604, or that's basically says here, I got the language for you, any person that acts with a specific intent to transfer on behalf of another person funds that are known by the initial person to be either derived from a criminal offense or intended to be used to promote or support unlawful activity would fall outside of the safe harbor. There's debate about inside the Bitcoin community about whether this is actually good or bad language, in the sense that the legal standard for proving intent is typically quite high, but kind of the broadness of the phrasing here, right? Specific intent. How do you ascertain specific intent necessarily? How do you know whether you intended to be used to promote unlawful activity, right? Again, the sort of way that we came to have this clause inserted into the bill was that the state district attorneys and, kind of, again, the more law and order members of the Senate felt that we couldn't, quote, lose the ability to charge the Samurai developers and Tornado Cash developers that we just saw happen because the powers that be feel that those were constructive and useful prosecutions, and they don't want to lose that ability. And so, I think where we are now with the language in the bill is that the whole industry or the trades in Washington, D.C., all the trade organizations, all of the kind of crypto lobbyists have communicated that the BRCA is a red line. If they water down the BRCA or remove it to the point where U.S. developers need to be fearful that they will be prosecuted and thrown in jail the way that the Samurai developers have been, that this industry will move offshore. And it's kind of set us up in this what would seem to be an existential battle now, where at least Bitcoiners have walked all the way to the edge of what is tolerable and permissible for us in a broader market structure bill. And now it would seem that we're going to get pulled across the line, and that they're going to further dilute this language in order to be able to get 7 or 8 Democratic votes on the floor, which are necessary to pass the overall market structure bill.
Yeah, this language in there which feels just kind of like a loophole, right? It feels like something that is, it's like, well, why does it need to be in there if it's not going to be used? And I know like Zach Shapiro from BPI has, and I don't know if his thinking has changed in this a little bit, but from at least what I read initially, his reactions on this, he was saying, look, and he's a lawyer, like, so he knows what he's talking about, right? He's a very good one. He's also a hardcore Bitcoiner, does great work with BPI as well. He was basically saying, look, I'm not too concerned about this. As you said, burden of proof to be able to show that there was specific intent like that from a legal perspective, that's very high. That being said, the fact that these states' attorneys general want this provision in there just makes like the red flag kind of go off and say, well, why have it in there if you're not going to use it? And we know specifically to take the Samurai case, we know that they were, one of the things in the DOJ's indictment was they were showing, just like tweets that Samurai had put out saying like, or not even oligarchs welcome. It was like, welcome to all the new Russian oligarchs after some of the sanctions and stuff, which is obviously like a joke. Like they have no idea if Russian oligarchs are using their service. They don't KYC their customers. They have no clue. But that was used as an example. That was used as one of the key examples in there. And there were a couple others that I'm forgetting, all of which were incredibly loose. Like either were very obvious jokes, or even if they weren't jokes, there was no way for them to know that what anyone is using their service for. That's like the whole point of their service is preserving privacy, right? And not knowing your customer and not holding their funds. Not, for instance, like JP Morgan Chase actually custodying, Jeffrey Epstein's funds to, launder all that money. And, they paid fines in the Virgin Islands for that. But we don't need to talk about Jeffrey Epstein's banker right now. We'll save that for another day. But that's what's troubling to me is that, okay, if they're going to use under the existing statute, they're going to, again, go against what FinCEN, because FinCEN, as you pointed out, said, look, the Samurai wallet developers, they're not custodying the funds at any point. So they don't meet our bar for what constitutes a money transmitter. Therefore, of course, they logically cannot be an unlicensed money transmitter because they're not a money transmitter. If you're going to use things like loose tweets to say, look, new Russian oligarchs were using their platform. That to me just seems like under this new provision, they would do the exact same thing. Oh, look, of course, bad actors are going to use your platform because it allows people to launder money. Therefore, that people are laundering money. Therefore, that people have the specific intent to launder money. It just seems like this is just like this isn't going to protect developers at all in my mind. And again, the fact that Zach is less concerned about this makes me feel a little bit better because I respect him. He is far more knowledgeable than I am on this. But as an outsider looking in without the legal expertise, I see what already happened. And then I see this provision and I think this almost feels like it makes it easier to go after developers. Unless I'm just really missing something, which is very probable, but that's just my gut reaction to this is like, this does not smell good to me.